Please be seated. The sitting is open. I would like to note that today the following judges are present with me in the Great Hall of Justice: Vice President Gevorgyan and Judges Tomka, Abraham, Yusuf, Sebutinde, Iwasawa, Nolta, and Charlesworth, and Judges Ad hoc, Pillay and Kress, while Judges Benuna, Shway, Bandari, Robinson, and Salam are participating by video link. The Court meets today to hear the first round of oral argument of the Gambia. I shall now give the floor to the agent of the Gambia, His Excellency Mr. Dawda Jallow. You have the floor, Your Excellency.
Madam President, honorable judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. Over 2 years ago, the Gambia filed its application with this court, exercising its right as a party to the Genocide Convention to hold Myanmar to account for its ruthless acts of genocide against the Rohingya group in Myanmar. My esteemed predecessor said that he stood before you then, as I do now, to awaken the conscience of the world and to arouse the voice of the international community. The court rose to that challenge and unanimously ordered provisional measures against Myanmar that have, to this very day, helped protect the Rohingya group from a repeat of the violent acts of genocide that Myanmar's military, the Tatmadaw, had inflicted upon them. We must never forget the Tatmadaw's mass murder, its coordinated use of rape and sexual violence as a weapon of genocide, its burning of villages with people locked in their homes, its targeted killing of children and the elderly, its murder of people as they fled these so-called clearance operations, and its order to kill all that its soldiers could hear and see. Justice and accountability for those acts of genocide and for Myanmar's ongoing acts of genocide is not just possible, it is necessary. A solemn obligation shared by the Gambia, every state party to the Genocide Convention, and the international community as a whole. It is why the international community drafted and adopted the 1948 Genocide Convention. It is why the Gambia filed its application against Myanmar over 2 years ago. It is why the United Nations, the organizations of the Islamic Cooperation, and the states around the world have welcomed and supported the Gambia's case. And it is why the Netherlands and Canada have publicly announced their intention to intervene under Article 63 of the court statute. It is why this court must reject Myanmar's meritless preliminary objections and proceed to adjudicate the merits of this dispute. Madam President, honorable judges, the Gambia may be a geographically small state, but we stand tall in the international community of states and take pride in promoting and protecting human rights and international accountability for atrocity crimes like genocide. We work bilaterally with other states and through multilateral institutions in our sovereign capacity for these and other national goals. It is a statement to the Gambia's diplomacy. It is a testament to the Gambia's diplomacy that the 57 member states of the OIC formally endorsed and supported our action before this court, not to mention the many others who have subsequently done the same. We are no one's proxy. As my predecessor told you at the outset of this case, this is very much a dispute between the Gambia and Myanmar. We seek to protect not only the rights of the Rohingya, but our own rights as a state party to the Genocide Convention by holding Myanmar to its enormous party's obligation and not to commit genocide, not to incite genocide, and to prevent and punish genocide. These violations of the Genocide Convention are a stain on our collective conscience, and it would be irresponsible to pretend that it is not our business. We make it our business when we, as civilized nations, committed ourselves to the pact under the 1948 Genocide Convention. At the last oral hearings, Myanmar raised the very same objections that are before the court now. The court rightly rejected them in its order of provisional measures. Nothing has changed that would warrant the court to depart from its previous unanimous decision, and we call on the court to swiftly reaffirm its previous rejection of these groundless objections. Now, even more than before, justice within Myanmar is impossible. And now, as before, only this court can hold Myanmar to account for its acts of genocide. Madam President, honorable judges, justice delayed is indeed justice denied. The Rohingya and all people of Myanmar deserve justice and accountability. The Gambia is grateful that the court has settled these hearings so that this case may proceed without further delay. As a state party to the Genocide Convention, the Gambia fully expects that the court will uphold its right to have this case heard on the merits. The Gambia urges the court to proceed as expeditiously as your careful deliberations allow. The Rohingya deserve no less. The Gambia is proud to be represented by a diverse team of international advocates who will address all of Myanmar's preliminary objections in turn. Mr. Paul Reidler will speak first to update the court on the developments in this dispute since 2019. Mr. Andrew Lowenstein will then demonstrate what should be the obvious point, that the Gambia is the applicant state and not acting as a proxy for any other entity. Professor Pert Dejean will establish the Gambia standing to bring this case as a state party to the Genocide Convention. Next, Ms. Tafazwa will show that Myanmar's reservation to Article 8 does not deprive the court of its jurisdiction, which is explicitly provided for under Article 9 of the Convention. Mr. Asalan Suleiman will confirm that a dispute existed between the Gambia and Myanmar over its violations of the Genocide Convention as of the time the application in this case was filed. And finally, Professor Philip Sands will provide concluding remarks for the Gambia's first round of arguments. Madam President, honorable judges, it remains for me to thank you for your courtesy, for your keen attention to this case, and for allowing me to address you. With your permission, I would ask that you called upon Mr. Reidler to address you virtually.